family law docket.
I have a quick matter on number 4, the Bingham and Bingham matter.
All right, 21-3.
We're here for a review hearing on Ms. Bingham's compliance as far as whether or not she's disclosed her employer and employer's address. At this juncture, neither my client nor I have received any verification. We did forward to Ms. Bingham the prior review hearing order setting this date, as well as my proposed order that we filed on Friday for the second order rate contempt review. Ms. Bingham did immediately call my office on Friday at 11:52 a.m. and said, "I do not want you to email me. I just got served by email. Stop messing with my employment," which seems to suggest she is employed. And so at this point, I'm simply asking to enter the order, and I guess we'll just let it sit out there until she decides to comply.
All right, and I just let 2 people in that are not identified. I don't know if guest or iPhone is Tanya Bingham. All right, hearing no response, I will sign off the order as presented.
Thank you very much, Your Honor.
Yes, and I did receive a notice of appearance from Mr. Anagnosio on the case. My suggestion is maybe setting this matter over another 2 weeks to allow the exchange of discovery and determine where we're at that point. I just don't want any real further delay in this case. It's been pending for some time.
And what I would ask for, Your Honor, is that the matter be set over 3 weeks. If counsel, I know counsel, I think, has sent me kind of a revised, scaled down version of what she needs. I just need some time to get her the response. And I think just given my schedule, I got Mr. Van Tongeren in because he was, my understanding, it was a very much deadline for today that he have counsel. So I just haven't had an opportunity really to look at the discovery and to determine how much it's going to take to get a response. So we get set out. I'll try to get it to counsel before that.
3 weeks is fine. I just want to resubmit it to the court that this is pending for some time. I would really urge that we need to move forward if we don't receive it on the 3rd. And I would also continue to reserve on fees. The other thing was, it wasn't set on today for presentation of the order. If we could also just note that it's on for review and presentation of the prior review hearing order, I'll circulate that proposed order to Mr. Anagnosio.
Okay, I'm fine with all of those things. We'll reserve on fees. We'll set it for presentation of the previous order as well. The only problem is the 25th is closed for judicial conference. So the 18th or the 2nd are the 2 dates that we have.
I'm apprehensive, but we'll do the 2nd. We just really need the discovery if it's going to be set out that far.
Any concerns with that, Mr. Anagnosio, for
No, Your Honor. June 2nd. No, that's not.
May 2nd? Sorry.
May. Are we talking May?
Yes.
Oh, I thought all these dates were in June or late May. May 2nd.
So that'd be a 4-week continuance.
I'm scheduled out the week before. Yeah, that works. I'll just do the best I can. May 2nd.
To May 2nd, 2023 at 1 p.m. for presentation of order and discovery review. And then please note that the fees are continue to be reserved.
Right.
Thank you.
I do have the proposed order. I'm reviewing that. All right. And do we have Gary Rapp present?
Yes, Your Honor.
All right. So, Mr. Rapp, I'm entering an order that basically is the findings that I made at the last hearing. So I'm going to sign off on that. You can get a copy of that through the clerk's office. We are reviewing a contempt.
Yeah, that's correct.
Okay.
That's correct, Your Honor. This is the contempt that was entered 5 or 6 weeks ago, I believe, initially by Commissioner Baldwin. It was reviewed by Commissioner Nelson, ordered that Mr. Rapp was to pay at minimum $1,000 to my client for maintenance payments as of today's date, this hearing. And so far I've seen $800 come in through the door. I think it was $500 a week or two ago, and then an additional $300 several days ago. So of 1,000, he's a couple hundred short. Court has issued attorney's fees and costs throughout this matter that, again, are going largely unpaid, and the arrearages towards the back alimony support orders, we continue to have issues with that. There is a settlement conference that's currently scheduled for June. Now, hopefully, we can get this case resolved there or before. I will be sending out Mr. Rapp probably a settlement proposal in the next several weeks. Again, in hopes of resolving him of a lot of these back support arrearages that he owes. But at this point, my client has been here, several times now for various motions since temporary orders were entered in the fall, and we largely have non-compliance. That's the latest from our end. I don't know what efforts or what plans Mr. Rapp has to pay the monthly support obligation moving forward. Again, he has the resources. We've been over that time and again. He has the pension, he has Social Security, and he has almost $1,000 a month truck payment. So there's manners in which he can come up and secure those funds, but to date, that's just been an increasing frustration and just not complied with.
All right. Is there any additional, other than the fact that he hasn't paid the full amount, any other requests of the court today as far as that contempt is concerned?
No, I don't think it does any good for Mr. Rapp to go to jail. I don't think that does anybody any good, and that only further complicates issues. I would suggest, though, if this continues to be an issue and we are before the court again, that be contemplated. That's the last thing that we want. My client has no desire to have him in jail, but again, we're kind of at dire straits right now on those support payments. So if we set a review hearing for maybe another month or so out, that might be the only way to get him to comply and track those payments. But again, what I don't want to have happen is I'm appearing and my client's throwing good money after the no money that she's not getting in support and paying for the services and the legal fees and such. Doesn't make a lot of sense either. So I think sporadic review hearings are probably advantageous at this point, with the understanding that if support payments are not made, then jail is a definite possibility at that time.
And I'm sorry, did you say that the MSC is June or July?
June. Late June. I believe it's the 28th or 29th. It's not till the end of the month.
All right. How about we set a review for May 23rd? So Mr. Rapp, I'm going to set a review for May 23rd, 2023 at 1:00 p.m. And that's just, we're going to start keeping an eye on payments. I don't want there to be just a, continuing filing of contempts based on you're not paying the support that was previously ordered. And then now affirmed by 2 additional judges and at least 1 commissioner. So, this is just the hope that you're making your payments. Mr. Zandy, I would authorize that review to be struck if payments are up to date at that point.
We'll do that. Thank you, Judge.
Thank you. Excuse me, Ms. Bliss and Mr. Klopp. There was a request for clarification. There was also a request for reconsideration, but they were largely similar. So I'm assuming that the clarification is really what's being sought here. And the main issue is the 2 different paragraphs within the parenting plan that say 7 p.m. exchange and then after school, or when school is in session after school. So I've reviewed everything, and the order very specifically on page 3, the exchange is at 7 p.m. So it's not after school every Monday. It's at 7 p.m. every Monday. So I don't know that the order needs to be changed to but that's what it is. I understand the concern and the confusion because the section 12 states they'll be exchanged at school when in session or Castle Rock Park and Ride. So there are times in the parenting plan where school is the point of pickup and drop off, and that's namely in some holidays that are covered here. But as far as the regular week on, week off schedule, 7 p.m. Mondays at the Castle Rock Park and Ride. Is there anything else that we need to clarify so we make sure we don't have any issues? Go ahead, Dr. Bob.
Oh, sorry. Yes, there is, Your Honor.
Sure.
To start with that, there's no way you could reconsider that to be picked up after school. Or is that just out of the picture? Changing that to after school rather than the 7 p.m. Just to limit all interactions if we could. Just because of the restraining order that's in place for one, and then for two, just so we don't have to do as little as interaction as possible.
Ms. Bliss.
And Your Honor, as contained in my client's declaration, it was specifically anticipated, their protection order was already in place or was going to be in place. Your Honor still ordered that the park and ride was to occur consistent with that. There were specific discussions during that initial hearing that Mr. Klopp had requested the exchanges occur at 7 instead of 6 is to not interfere with dinner time. So it was fully anticipated that the interactions would occur at 7, which is essentially status quo. It's an hour different than what the parties had been used to. There's no basis to make that request currently. I understand that he brought a reconsideration, which I think the court is aware this isn't the real proper venue for that, as those are typically done on the pleadings. But nevertheless, there's no change of circumstances between the last hearing and today. There's no real basis to switch that at this point. And so we would ask that it remain as it is, as it was fully anticipated and fully considered at the first hearing.
So, and I'm reviewing, Mr. Klopp, your initial request when we went into that hearing a couple weeks ago, and your request, initially it was 6, then it was 7. You specifically asked for it to be later so dinner could be concluded. When the exchange happened, there was never a request in my notes or in the court record for after school exchanges. Frankly, I have no idea what that restraining order is about, why it was filed. There should never be an issue with exchanges between parents, step parents. It should be civil. There's a child present. So I don't know what the issue is, but that's so I'm not going to change the 7 o'clock. It was what was contemplated and requested frankly, by both parties. So I'm going to leave that at
Thank
7.
you.
Anything else, Mr. Klopp?
Yes. And then the New Year's Eve schedule, I feel like also kind of interacts with the winter break schedule. New Year's Eve, isn't that's still in the winter break? Is that how that works?
Generally, yes. So are you confused or concerned about essentially an added exchange in the middle
So
of
there
the
would
second
there
half?
would be another exchange in there on my year or her years. So if it was like my winter break for the last part of the winter break, Lacey would be getting him again on New Year's Day. Are you seeing what I'm saying?
I am seeing what you're saying.
Okay.
Ms. Bliss?
Not sure.
And Your Honor, I didn't really take a position on this. Your Honor made the change as to the Christmas Eve and day schedule, providing essentially for a Christmas break split schedule. It's not uncommon that we celebrate Christmas or New Year's, even with the inclusion of a winter break. I don't think there's a real basis to make a request to make a change, but I'll defer to Your Honor.
Is this the concern just the exchanges?
Yeah, just the fact that like he would be like, if it was my winter break still, he would go back with his mom for one day for New Year's Day. So if we could swap the years, that would change it, or the wording to where I could just have him the full winter break, which is, could we add like the New Year's as part of the winter break, I guess is the easiest way to put it. rather than having the swap.
Does Ms. Bliss, does your client have a strong position on that? Like New
No,
Year's
Your Honor.
Eve isn't like a big family, okay. Because
Not
to
to my
me,
knowledge.
the easiest thing to do would potentially be just on the New Year's Eve portion, just in odd numbered years with father, even numbered years with mother. Because then it would essentially be consistent with, or it can just be struck. So I'm fine taking that out if neither party has any strong feelings about New Year's Eve. So Miss Bliss, I know you're leaving soon, but I guess I would ask if you think it would be easier to just strike the New Year's Eve portion.
You knew that.
And then the best way to do that, to keep a good record, do you want me to do a bench order, or do you want to present something ex parte?
I think it might be cleaner to just strike it from the parenting plan and just submit an amended temporary parenting plan. So that way we can just refer to one parenting plan instead of a parenting plan, a bench order. I think it's just cleaner and less confusing
Okay.
that way.
All right. Well, I would hope that since all we're doing is printing and omitting, we can get a signed order, an agreed order from the parties, and I will sign it and file it as soon as I receive it. So Mr. Klopp, can you work with Ms. Bliss's office on getting your signature on the order that will just omit the New Year's Eve language?
Yes, ma'am. Yep. We
All
can do
right.
that.
And then once I receive it, I will file that.
Cool. Awesome.
Anything else?
Yes, and then my biggest one also was the first right of refusal. So on days that I do work, Lacey still hasn't given me a schedule of her work. So I have an issue with giving him to Miss Dahlman when I'm at work, because I don't know if she's at work or not. I feel that it's not beneficial to Brody for him to go to his mom's house while she's at work. I know she works from home, but I still feel like he just gets stuck having to play video games or do things that aren't very proactive for him when she's working. And I don't know what days or what times she works, because there's never been a schedule given to me. She knows my work schedule. I've worked the same work schedule for 8 years. Hasn't changed. I can leave work anytime I want. My work is amazing. I just feel like the first right of refusal, I feel like if he has the opportunity to go to a grandparent's house or have my fiance watch him with his other siblings, I feel like that should be an option rather than have to go sit with his mom while she works. I just don't feel like it's very proactive for him or good for him to have to do that. On days that she's not working, that's fine. I understand, but I have yet to see a work schedule.
Ms. Bliss?
And Your Honor, as my client has testified in numerous declarations, she does work remotely. She works when the child is in school or otherwise not in her care. It's my understanding there is no issue with her working. If he needs a work schedule be provided to him, I don't think she has any objection to that. Although it's not the order of the court, the order of the right of first refusal simply states if a parent is unable to do so or is working there to afford the other person the opportunity to watch the child, not I need to give you my work schedule, you need to give me your work schedule, and then we'll coordinate. That's just not typically how it works, and that's not what the order is. If that's what Your Honor is going to order today, my client has no objection to that.
I'm not going to order that. I think it's beneficial to share that information. I'm not going to change the right of first refusal. I appreciate other generational family members being involved in these kids' life. I think that's very important. But it's a relatively common ask. And even with the concerns with the exchanges, I'm going to leave it in there. And I would just hope that if she's willing to provide her work schedule, that's something that they can find some mutual grounds on. I agree that, I think the order says over 4 hours. Is that right? I think it's over 4 hours. If they both agree that, okay, it's going to be 4.5 here and there, and it's okay to be with grandpa or whatever, that's fine. But I'm not gonna change the order as it is. That doesn't mean that you can't work with each other on figuring out how to best approach that for your child.
Okay, so just contact her and figure out if, hey, can you go spend the day with so-and-so, or I guess.
I think communication is important. And so, I mean, she has a right to say, I want to take them for that 5 hours that you're not available because of the order. But if you speak with her, and she also has a right to say, no, it's okay, you can take them to grandpa's, or you can, so my hope would be that you'll learn to work together for the best interests of the child.
Okay.
All right. Thank you for raising these issues. If you, it's good to get clarification when you need it. So
Right.
hopefully this helps moving forward.
Awesome. Thank you so much. Appreciate
All
it.
right. Good luck.
Thank you.
Mr. Klopp, I will send that to you after court this afternoon with that removal of the New Year's Eve language. So if you could just review that and give me your signature, and I'll submit that to the court.
Will do. Awesome. Do I need to bring it to your office? Sign it and bring it to your office? Or?
No, and I can send it to you via electronic signature. We'll put that in the email as well. So if that's easier for you, that's fine.
Awesome. Thank you so
Okay,
much.
We have a motion to modify. All right.
Thank you, Judge.
Visitation.
Yes.
Thank you. All right.
Yes.
Well, I guess for the record, I have reviewed everything that's been filed since February 7th of this year. And I also reviewed the current parenting plan. So.
Okay.
Your Honor, Stephen Swenson for the respondent, Gabrielle Evans. Has Your Honor reviewed the GAL report from last year?
I believe I did. Let me double check. Do you have the date that was filed, Andy?
Exactly 1 year, I think, from today, April 4th, 2022.
Oh, there it is. Okay. Let me just make sure. Miss Long. Yes. All right. I just reviewed the 4/4/22 report and the 4/21 supplemental of the GAL. Okay. Now I think I'm ready.
Very good. Thank you, Judge. And on behalf of the petitioner and moving party, namely Anthony Heinzman, we are before the court today on my client's request to modify the temporary parenting plan or temporary visitation schedule. As contained in my client's motion and declarations, he currently receives 3 hours once per week of supervised visitation with the child in this matter, Elijah. Those visits are supervised by Ms. J. Gruber Evans's mother, Sienna Nash. We were previously before the court a few times last year with similar requests. However, my client acknowledges that a substantial difference has occurred in the last year, and he has made substantial progress, which prompts him to bring this motion back before the court. My client has had supervised visitation with his child for over a year at this point. There's been 0 documented concerns with those visitations. I will acknowledge that Ms. Nash and Ms. Evans have provided declarations indicating essentially that they would do visits differently. There were no safety concerns noted. There were no real concerns as to my client's ability to care for the child, with the exception of, he, is letting him watch Moana, or he's on his cell phone. There is no safety concern as to the child and no real basis to continue this supervision requirement. Since those orders were entered last year, my client provides for the court that he has taken a parenting class, which was recommended by the guardian ad litem. He has, let me backtrack. As Your Honor is aware, with the guardian ad litem's report, it was during the time period where recommendations weren't requested by the bench. So it kind of puts us at a little bit of a disadvantage because we don't really know how to proceed. But looking into her recommendations or her report, she indicates that my client shall gain some knowledge as to how to deal with his behaviors and his anger, largely as to how that's going to affect Elijah and how to further parent him. With that recommendation or that report, he has gone and completed a parenting class. What was recommended by the guardian ad litem, in so many words, and ordered by the court, is that he undergo a mental or a domestic violence evaluation. He has completed that evaluation. The provider had recommended 38 weeks of treatment. To date, he is roughly 9 weeks away from graduating that treatment. He's provided compliance reports that suggest that he's getting 3s and 4s for his treatment, which is satisfactory or consistent with the treatment program. And those have been consistent over the last several months. He acknowledged that when he first started the program, he was receiving 2s and 3s, which isn't uncommon for folks just entering the program. However, you can see since that time, he has progressed. Most notably, he received a 4 and appears to be motivated to improve himself, which I think is very important for the court to consider. Mother's allegations are that he's going to continue the alleged domestic violence behavior, that he's going to continue to be a risk to the child. However, the professionals involved in this case seem to think otherwise. They've indicated that he is improving himself and is appearing motivated to improve himself, which I think speaks volume as to his engagement in this treatment that was required by the court that he be completed. We're at a point now where he's had supervised visitation with his child for over a year. The supervision requirement that it be with the mother of his child, but most notably his ex-girlfriend's mother, is obviously uncomfortable. It prevents the ability for Elijah's paternal family to really be involved. I'll note that in Miss Evans's declaration, she states his family is more than welcome to come. However, I think the court can take judicial notice that having other family members in the home of your ex-girlfriend's mother is simply uncomfortable, and it's not a real place for the paternal bond to continue with Elijah's paternal family. My client provides to the court that prior to the parties' separation, his family was very much involved with the child's life. His mother, most notably Elijah's paternal grandmother, was very involved with the child. Since over the last year, with those supervised visits being intact, that bond hasn't been able to flourish or hasn't been able to be continued because of the supervision requirement. My client is asking something that's not unreasonable, not something that's uncommon in cases such as this, that over a period of time, parties progress through visitation. He's simply asking that the supervision requirements be lifted at this point, given the fact that there has been no showing that there's a safety risk to the child. Looking at RCW 2609-191, it suggests that a parent's visitation shall be limited if there's a safety risk or if there's a well-being, or the child's well-being is at risk, and that simply is not proven here, and it's not supported by any evidence here. What has been provided is simply Ms. Evans and her mother would do visits differently. That's not the standard. That's not the case law or the statute suggests. It's time for my client's visitation to be increased and to be less restrictive. My client does have the parental right to have visitation with his child, and there has been no showing that he's a danger to this child, at least over last year, arguably before that, but I do understand that the record is clear that there's some domestic violence allegations, there's a finding, so on and so forth. But for the last year, there's been no showing that any of his visitations have been inappropriate, that he has been a danger to this child or the child's safety is at risk when he is in his father's care. What we're asking for is a phase-up plan, which arguably, had the guardian ad litem been permitted to provide recommendations, I imagine that she would have provided, given the fact that her report suggests that father's time should gradually increase as he progresses through the process. So that's what we're asking for today. We're asking that the visits continue on the same days that they're currently occurring on, which is consistent with my client's rotating work schedule. So every first 2 Saturdays and third and fourth Wednesdays, instead of being a 3-hour supervised time, which they are currently, we're asking that those increase to 6 hours of unsupervised time, that occur for a period of about 4 weeks. Obviously, I'll defer to the court if you feel that that needs to be longer, but this is just what I'm proposing, that those occur for about 4 weeks. After that time, assuming that there's no concerns, or if we want to renote it for review as to how those visits are going, we would ask that those increase to 10 hours, still occurring on those same days for another period of 4 weeks, and then that we begin introducing overnight visitation. Again, I don't think that this is unreasonable. He's slowly progressing his time as he understands it's going to be an adjustment period. However, both Elijah and my client deserve the opportunity to continue to build their bond and their relationship. That is the request that we have before the court today. Again, I acknowledge that we were before the court last year, which I know is a huge point of contention in Ms. Evans's responsive declarations, that we've been before the court before, that the court's already made a ruling on this, that we don't need to be back before the court, we need to go to trial. The fact of the matter is my client and this child have had supervised visits for a year. There have been no issues. There's no basis to continue supervised visitation for an extended period of time, even longer. This matter isn't currently set for trial, so we're looking at potentially another year before we're even at trial. And there's simply no reason to continue to limit my client's visitation with this child. He has done what has been ordered and what has been requested of him, taking parenting classes, doing domestic violence treatment, complying with the orders of the court. So we are asking the court to approve our request at this point.
And he has, excuse me, a month or two left in the 38-week program. I think it's 38 weeks. Is that correct?
By my count today, it was 9 weeks, so just over 2 months.
Okay. All right. Thank you very much, Mr. Swenson, whenever you're ready.
Thank you, Your Honor. Stephen Swenson for the respondent, Gabrielle Evans. We're opposing this motion because really this matter should be going to trial. It started a year ago. A GL report was filed a year ago. There's no reason to piecemeal visitation every few months with a different judicial officer. Your Honor is the third judicial officer to hear basically this same motion about supervision. We're ready to move to trial, and I believe that allowing the petitioner to move to change it bit by bit with every small change of circumstances actually incentivizes him to delay trial and actually have a full hearing on the record. As Your Honor probably saw in the GAL report, there's numerous police and DCYF interactions with the petitioner, Anthony Heintzman, for allegations of child abuse, punching a 5-year-old in the face, pushing the shared child's face into the side of a crib, lifting a child up by their throat. There's also allegations, and it was testified in the protection order of DV of punching my client in the stomach while she's pregnant, grabbing her and leaving bruises, and breaking down the door with the client and my client and the shared child on the other side of that door. And he stated on the record, which is in the GL report, that he broke down the door because she slammed the door in my face while I was talking to her and I was not done speaking to her. It was my house. I busted the door down so I could finish my conversation with her. Now, he's saying what's changed is he's been taking DV courses, and out of 5 being the highest, he's been getting 2s and 3s consistently. It wasn't until the last report that he got 4s. And those 3 of those 4s, one is for participation, one's for paying program fees, and one appears motivated. But he's been getting 2s and 3s for understanding power and control and domestic violence, and for taking responsibility for his actions in this. And if you can't take responsibility for your actions, you can't change your actions. He's going to continue them. What we see in the declaration of the supervisor, he's been telling the child to hug him or tell him he loves him, and if he doesn't, he'll put the child in trouble. He'll give him a timeout or something, which is abusive behavior. It's power and control. And so we're asking that this supervision continue. In RCW 191, it says if there's a history of acts of domestic violence, parenting should be limited. The reason there hasn't been any safety concerns during supervision is because supervision works. People, when they're observed, are on their better behavior. And so, yes. And he's also not taking co-parenting seriously. It was approved that he could use the Our Family Wizard app to rearrange parenting or send parenting messages in, and he's refused to use the application. He has no interest of co-parenting with my client or in even using an application because he could be observed while doing it. For those reasons, we're asking that the motion be denied. Also, going back, he states that he doesn't want to do supervision at his ex's mother's house. The parenting plan has always allowed him to go to Beth Fellows, a professional supervisor. So if that's the issue, he could have gone to Beth Fellows from the beginning. Thank you.
Just a quick question. Has there ever been any other thought or consideration of another supervisor that wasn't maternal grandmother or professional?
That was requested by my client last year, and it was denied by Judge Morning.
And by Judge Hahn later.
I do have to say 2 things. he's following through. So we're in a different position now. And because he's started taking the programs, he's done the parenting class. And I guess I would disagree a little bit with Miss Bliss, because it does appear to me on the GAL report, and maybe they're not the way that they are now, but I do show recommendations. A mother being primary decision maker, court should consider this, visits should occur this way, and the frequency, and in the amended GAL report from 425, it does say visitation frequency and duration may be increased upon documentation verifying father's participation in parenting educational programs with specific focus on care for toddlers with effective age-appropriate discipline. And then overnights should be reserved for documented progress and DV treatment as recommended by Miss Lovely. So does appear to me that both when this was reviewed at that point in time, and then was June or July by Judge Hahn, he hadn't started any of those programs yet, nor shown completion of a parenting plan. So I think we're in a different position than we were before. It does indicate our family wizard, and it does. I don't know that I haven't given Miss Bliss a rebuttal yet, but I don't know if there's some aversion to our family wizard, and if there's any. I guess I'd like to know about our family wizard, and I'd also like to know if there has been any discussion or any willingness to consider a different non-professional supervisor for these visitations. So whatever you want to answer that, Ms. Bliss, the table's yours now.
Absolutely, Your Honor. I would just note first, I know you have some questions and I'm more than happy to answer them. I would just note for the record and for the court, despite counsel's allegations that there were numerous CPS allegations, numerous allegations as to child abuse, there was never any findings, first of all. And second of all, there was never any criminal action brought based on those allegations. So I think that should be noted for the record. Now, to answer your question with our family wizard, I will note that at the time of the guardian ad litems report, there was a protection order entered by Ms. Evans against my client, which restricted a lot of communication. That order was requested to be extended this past year, which Judge Morning allowed. So as of right now, there's a protection order in place. I don't have that protection order in front of me, so I don't know if it specifically limits contact, but I do know that that is the reason why my client is apprehensive to have communications with Ms. Evans, first and foremost. Secondarily, early on in this case, Ms. Evans demanded that communications be between her mother and my client. So he's essentially just continued status quo. So I think that's my client's position as to the phone visits. As to an alternative supervisor, and don't quote me, I might have removed that, but I thought maybe I had addressed that in my motion as well, as either removing the requirement completely or changing the supervisor. I might have taken that out, but regardless, my client has no objection to continuing supervised visits. If Your Honor thinks that that's appropriate, he would request that it be an alternative supervisor. He has in the past requested that his mother supervise. I know that Ms. Evans has had an objection to that. However, as Your Honor indicated, we're in a completely different, not necessarily completely different, but we're in a substantially different climate now than we were at this time last year. So that would be a proposal that my client have. Anything beyond that, I would need to confer with him because I don't have that information readily available.
All right, I'm pulling up the protection order because I just want to see if there's any. Thank you for answering those questions. I just want to see if there's any language in there that allows for potential communication through the app or anything like that.
Looks like an other finding that says parenting plan controls in case of any inconsistent language.
And I had communicated with Miss Bliss in June of last year while discussing our Family Wizard app, and it was her opinion that that language allowed them to communicate through the app without violating the order, which we agreed.
And looking,
So I just want to make sure. So Mr. Svensson, your client is fine receiving and sending communication with Mr. Heinzman through our family wizard and not
Correct. And
seeing
she-
that as some kind of a violation.
Yeah, correct. In which we'd communicated to Ms. Bliss. And she's tried to communicate with him multiple times. And the mother had indicated she didn't want to pass messages, which was in the June hearing, which is why we included our family wizard app request.
Okay.
I guess if Your Honor included that in an order, I don't think that it would be a violation. Just looking at the initial protection order entered December 3/21, it just says that he's restrained from having any contact whatsoever. And then there's another handwritten, this is subject to any court-approved parenting plan. So I guess in that instance, if Your Honor were to order that the parties communicate via our family wizard, then I think that wouldn't be a violation and that would be acceptable.
Okay. Well,
And can I address you'd asked if there's been a discussion of different non-professional supervisors.
Sure.
There have been numerous other proposed non-professional supervisors by Anthony Heinzman, and the court rejected all of them for various reasons, because I think they were family members or they were other people who, I don't know, if the court just didn't agree with. So I don't know if my client has anybody else to propose, but and his mother apparently lived like 40 minutes away, I think. Sorry, that doesn't really answer your question, but except that they're
well, no,
asking for
I'm glad to know that other people were considered at some point. Here's where I'm at. So I reviewed everything. I think there's the potential for a slippery slope on reworking temporary parenting plans prior to trial. But clearly there were a bunch of limitations put on Mr. Heinzman, and he was given a list of stuff to do, and he started doing those things. So to be very frank, when I reviewed all of this, I understand the concerns. There's nothing in the record other than, I don't know. I personally have not seen Moana. I don't know how many times. I guess back in the day, I probably watched Little Mermaid way more than was necessary. But I don't. There was nothing concerning in any of those notes from Grandma. What my initial thought was when reviewing all this is, let's try the same schedule that we have now. Same hours that we have now, unsupervised for 2 months, and come back at the end of that. Obviously, if there's concerns or issues, it can be brought back prior to that, but that's where I'm landing. I think Mr. Heinzman has been working on these things. He's consistently attending these things. Maybe he's not making the progress we all hope or want him to make, but he's making progress and he is attending, and he's putting in the time there. So I'm not gonna do a full phase up plan. I think that may be a little much at this point. Plus, I want to see how it goes. So I'm gonna authorize the same visitation as now, only unsupervised. And I'd like to set a review on that, not too far out. If anything concerning arises, then I would expect to see it sooner. Go ahead, Mr. Svensson.
And because in this case, there was never, I think, a full parenting plan entered with decision-making, I would just ask that my client be given decision-making in these matters so that, there's no medical treatment or religious choices happening, just because
No, I understand
no
that.
parenting plan, and also just prohibitions against, speaking ill of the other parent, having used cannabis or alcohol or any non-prescribed drugs like 8 hours before, just kind of the typical restrictions we see in parenting plans.
I think those are all appropriate. So I think decision making will stay with mom at this point. We'll keep the same schedule as we have now, only unsupervised. And I know transportation was one of the issues that she raised, so I don't want to make that even more difficult than it is. No non-prescribed drugs, medications up to 8 hours prior to or during any visitation. Also, no alcohol prior to or during visitation. No disparaging comments about any of the other parents or parents' family members. And I am going to order that the Our Family Wizard app is being used because mom may need to get a hold of dad when dad has child. Dad may need to get a hold of mom when dad has child, and they need to have a way to safely do that. So I think Our Family Wizard is paramount to that. So I'm going to order that be the way of communication moving forward, since that's agreed by all the parties.
And I also have a prohibition against physical discipline.
Yes.
Absolutely.
So it's standard language on that, Miss Bliss, would be great.
Yep.
And then
How do we want to,
go ahead.
what do we want to do the transportation? Do we want to continue with, so I know Miss Evans has arranged for a village to help with the transportation. Do we want to still have visitation essentially starting at Miss Nash's so that her transportation brings the child to Miss Nash, my client picks up from Miss Nash and goes on his merry way? Or do we want to reach a mutual meeting location, or how do we want to word that?
I think that would be easiest for everybody.
Okay.
We'll just keep everything as is, only Mr. Heintzman can leave with the child during those 3 or I don't remember how many hours it is. 3 hours, 4 hours? Okay.
3.
And then let's you're out towards the mid-late of April. What if we review the 23rd of May? And then obviously if we want to bump it up, if there's any concerns, by all means, please do that.
That works for me.
All right. So we'll review
Or
this.
would it be the, yeah, sorry, I thought today was Wednesday.
23rd at 1:00. All right.
Do we want to set a presentation hearing, or Mr. Swenson, do you think that we can just enter an ex parte?
Let's enter a presentation just in case, and if we can agree, then we can just strike it.
I can, well, when are you back, Miss Bliss?
So during judicial conference is my first week back, so it'd have to be May 2nd if we're going to, if we can't get it entered ex parte in the next week, it'd have to be May 2nd.
I'm available May 2nd.
Okay.
Okay.
We'll put it on May 2 at 1. And then if I see that order come through, I'll get it signed and entered right away if it, and we can strike that.
Very good. Thank you, Judge.
All right. Good luck, everyone. Thank you.
Thank you.